We are on the record. Good morning.
Good morning, Judge.
Good morning, ladies and gentlemen. Welcome to Carroll Circuit Court. As Officer Bode has indicated, my name is Fran Gull. I am a judge in Allen Superior Court in our criminal division up in Fort Wayne, Indiana. I am serving as special judge in State of Indiana v. Richard Allen, 08C01-2210 MR1. I was appointed November 3 RD of this year by the Indiana Supreme Court by Chief Justice Rush. I will show that the defendant is here in person with his attorneys, Mr. Bradley Rozzi and Mr. Andrew Baldwin. The state is here by the elected prosecutor, Mr. Nicholas McClelland. We are here today on the state's verified request to prohibit public access to a court record that was filed with the court October 28 of 2022. Before we begin, I just would like to inform those of you present here in the courtroom of the courthouse management and decorum order that was entered for this hearing November 22 that I entered with the court on November 18 of 2022. The attorneys received this order, so they know what to expect, and you've already, ladies and gentlemen in the gallery, experienced some of the directives. Only one entrance to the building was open, you were searched, your bags were searched. If you have your cell phone here in the courtroom, again, please ensure that that cell phone is off, and no other electronics are permitted in the courtroom. I will tell you, consistent with my practice in Allen Superior Court, if your phone goes off, I will have it confiscated and it will be destroyed. Ladies and gentlemen, please remain seated throughout the proceedings as we go through this hearing this morning. If you must leave, please, do so quietly and, please, do so with the least amount of disruption possible. Once the hearing is concluded, I would ask that you remain seated until the parties and the court have left the courtroom and courtroom security indicates that you may leave. Mr. McClelland, on October 28 of this year, the Carroll Circuit Judge granted your verified request to prohibit public access to a court recorder and ordered the charging information and the probable cause and other court documents sealed and deemed to be a confidential court record pending public hearing. That order scheduled November 22 at 9 a.m. to be that public hearing. Under the Indiana Rules of Court, the rules on access to court records that were effective January 1 of this year, the burden is on the state of Indiana to demonstrate by clear and convincing evidence that the requirements of Rule 6, Paragraph A have been satisfied. Since we are proceeding under the Indiana Rules of Court, the rules of access to court records are not applicable. The Access to Public Records Act under Indiana Code requires the state to proceed under the rules of trial rules, so we will be proceeding under that. Therefore, no public testimony or comment is necessary, as that is only required under the Access to Public Records Statute Title V. So, gentlemen, are you ready to proceed?
Yes, ma'am.
Yes, Your Honor.
All right. Mr. McClelland, you may proceed.
Thank you, Judge. As the court mentioned, the state did file a verified request to keep the records confidential and specifically the probable cause affidavit and the charging information. The state's proceeding under Rule 6, and what Rule 6 says, Judge, is, in extraordinary circumstances, if the state showed that public interest will be substantially served by prohibiting access or the access will create a substantial risk of substantial harm to the state or other persons or the general public or that a substantial substantial prejudicial effect to ongoing proceedings cannot be avoided without prohibiting access, the court can restrict access to those records. As the court said, the burden's on the state. I must show by clear and convincing evidence, that at least one of those requirements are met. Doesn't have to be all of them, Judge, just one. And then, if the court does decide to keep the probable cause and charging information confidential, the court's required to do so in the least restrictive means necessary. So, Judge, in that effort, I have decided to present a couple of exhibits for the court to consider. I've presented those exhibits to the court and I want to go over those exhibits, Judge. I've presented those to the defense I have in court today as well. Exhibits what's been marked as State's Exhibits 1 and 2. Judge, those are affidavits from Exhibit 1 is ISP Detective Jerry Holman, and Exhibit 2 is from the Carroll County Prosecuting Office investigator Steve Mullen. Have both been involved in the case for several years. They have intimate knowledge of the details of the case. They both believe, in their affidavit, that releasing information would jeopardize the ongoing investigation. The next exhibit, Judge, is State's Exhibit 3. That's a letter from Becky Patty. That is L.G.'s guardian. She's in favor of keeping the records confidential as well. And then, Judge, Exhibit 4 is an online petition that circled not only the county, the state, and the nation. There is over 40,000 signatures on that petition, also petitioning the court to keep the records confidential. The state's moving to admit those 4 exhibits. Judge. State's Exhibits 1 through 4 offered.
Any objection from the defense?
No, ma'am.
Jody, I'll have you mark those as State's Exhibits 1, 2, 3, and 4 as reflected by Mr. McClelland, please, and show those admitted without objection. State's Exhibits 1 through 4 admitted.
Thank you, Judge. Judge, there's not a lot of precedent for a hearing like this. I've searched high and low for case law, talked to several people, there's just not a lot of precedent. This is an unusual situation, an extraordinary circumstance, if you will. The state is confident in the evidence that's been presented in both the probable cause and the charging information. We're confident of that evidence and of the contents, but I am concerned. I have 2 concerns: the continue ed investigation and then protecting the witnesses involved in that case. Judge, those are my 2 main concerns. It's my job as the prosecutor, in part at least, to enforce the law in an effort to protect the community. It is the public interest for me to enforce that law to protect the community. The first concern talks about the integrity of investigation, and I think that falls under the public interest factor and consideration for the court. This is still a very ongoing investigation. Our goal is to find anyone else who was involved in this heinous crime. That is the public interest, to find anybody else involved and get justice for A.W. and L.G. We still get tips every day. Tips come in every day. We have good reason to believe that Richard Allen is not the only person involved in this, that there may be other actors involved. That's why we left the tip line open. That's why we left the tip email open. The question becomes, at least in the state's mind, is it more important to release the details of the investigation to the public, or more important to keep those confidential in order for the investigation to continue and find anyone else that's responsible? The public has an absolute right to the information. I don't deny that, Judge. But at what cost? This rule was designed for extraordinary circumstances where the court can limit that access. The state believes that this is one of those extraordinary circumstances. Keeping the record confidential serves the public interest. It puts the investigation in the best position possible to determine if anyone else was involved. It is in the best interest of the public that the investigation find anyone else involved. The second part that I'm concerned about, Judge, is the safety of the witnesses and other people involved in the case. We have seen the extraordinary lengths the media has gone to in order to get the next soundbite or the next clip for their broadcast. We are a society of people that has to know right now. Social media, Facebook, Instagram, we want all the information right now, immediately. The media has went to great bounds to interview anybody involved with the case. Mr. Allen's wife, Mr. Allen's old neighbors in Mexico, they've staked out his house. They've went to these extraordinary circumstances to get anything they can involved in this case. Even by Richard Allen's own admissions, a letter to the court asking for a public defender, they forced his wife to move and abandon their home. We also know the prior judge, Judge Diener, recused himself by his own admissions to an email to the court judicial staff. He had concerns for his safety, for his staff due to the facts surrounding the arrest, so much to the point where he felt it was necessary to get out of the case, Judge. And so the state believes these are real concerns for the witnesses and the people involved in this case. Look at the amount of security we have here today, Judge. We don't have a lot of security in Carroll County, but I can tell you my tenure here, I've never seen the display of law enforcement that we have here today. This is a highly publicized case. We've had countless meetings over the couple months, or past month about security, how to get Mr. Allen in here, all for the safety of everybody involved in this case, Judge, and that should extend to the witnesses and should extend to the other people involved in this case. The court can imagine the media pressure, intimidation, and evidentiary issues that may arise if the name of the witnesses are released, and those witnesses are subject to constant harassment and bombardment by the media. The state also has concern that they may be interviewed on the 6 o'clock news and their testimony will be taken as such. That causes evidentiary issues. Some of the witnesses were juveniles at the time. They are now 19 and 20, in their first and second year of college. They need to be able to focus on what they're doing in school and not be worried about the constant harassment from media. And I'll remind you, Judge, some of the witnesses are still juveniles, and so there's concerns there. Again, Judge, the burden is on me. I have to show by clear and convincing evidence. And so the gauge starts at the presumption that the information should be released, and I have to convince you to move that ticker far enough to keep it confidential. And so, Judge, I looked up clear and convincing. We don't deal with it a lot, we deal with beyond a reasonable doubt, and so I looked up the jury instruction for clear and convincing. The jury instruction says the facts supporting the claims are highly probable. Look what we have here today, Judge, the chaos, the amount of attention this has drawn, the concern for safety. Defense counsel, the state, everybody has had a concern for safety for themselves, for Mr. Allen, for everybody involved. Went to extraordinary lengths to protect everyone here today. We can't look at this case like any other case. This is an extraordinary case, it is by its nature. The state believes it's important and allowed under Rule 6 to keep the PC and the charging information confidential, not only to protect the integrity of the investigation, but also to protect the witnesses in the case, Judge. So the state respectfully would ask the court to continue to keep the PC and the charging information confidential. However, if the court deemed that those items should be released, the probable cause and the charging information, I would ask the court to consider redacting the witnesses' names to protect their identity and the people involved in this case. In an effort to do so, Judge, I have a redacted charging information and probable cause that I'd like to submit to the court for their consideration. It has the names of the witnesses and the people involved in the case redacted, Judge. And if the court so inclined, at this time I'd like to at least admit that to the court not as an exhibit, but as for consideration for the court to consider a redacted version, as opposed to releasing the entire document.
Any objection, gentlemen?
No, ma'am.
Okay. Thank you. I won't mark this as an exhibit. This will be my work product, so it's not available to anybody other than myself and my staff.
Thank you, Judge. So, Judge, I'm about done. I wanted to leave you with one last thing. As I said, I did a lot of case law research to find any support of my motion or anything that is not in support of my motion. I came across a case, Brown v. State, Indiana Supreme Court case. It's from 1969, it's old, but I wanted to read you a quote from that case, because it kind of hit home dealing with the circumstances that we have today, and the court says this: the right of the news media to fairly and accurately report the news, the right of the defendant to a fair trial before an impartial tribunal, free of influence of generated prejudice and inflamed passion of the community, and the right of citizens to fully comprehend and analyze the administration of the court system, are elements necessary to the attainment of justice. Elements necessary to the attainment of justice. If any one of these rights fall, the rest will surely fall, and the term justice will become hollow and meaningless in our constitutional system. Judge, again, the state's asking that you keep those things sealed. I appreciate the time here in court today, and I appreciate you allowing the state to have entered exhibits and make an argument. Thank you, Judge.
Thank you, Mr. McClelland. Mr. Rossi.
Thank you, Nick. Judge, let me just start by saying that Mr. Allen in this case seeks transparency. It seems to me that, in the normal course of operations in our courtrooms around THE State, that's what we get. That's the norm, and really there's no reason in this case to sway from that. I would point out first, if I could direct the court to the pleading that was filed on October 28, 2022, the verified request to prohibit public access to a court record. This pleading, if you look at it, is deficient on its face, and I would direct the court specifically to the fact that Rule 6a specifically says, a verified written request to prohibit public access to a court record may be made by any person affected by the release of the court record. It requires a verification. And a verification, in our business, that word is a term of art, as you know. I see. 1-1-4-5 codifies the very essence of what a verification is. And what you're gonna find, and I would direct the court to Smith v. King 7, excuse me, it's a little dark in here, frankly. 716 and .2 D 963. It's a 1999 case involving an election dispute. Specifically, Headnote 3 of that case addresses what a verification is, and what the minimum standard to meet that verification is, and it says, when applied to plea in GS, verified means supported by oath or affirmation in writing. Pursuant to Trial Rule 11b, it's sufficient if the petitioner simply affirms the truth of the matter to be verified by affirmation or representation in substantially the following language. And it says, quote, I affirm under penalties for perjury that the foregoing representations is or are true. End quote. The essential purpose of a verification is that the statement be made under penalty of perjury. And it cites Austin v. Sanders for 92 in .2 D8, 1986. This document contains no verification which references that it's been signed under the pains and penalty of perjury. So I think it's facially deficient, and I would ask the court to consider that before we even get to the rest of this. And of course, I can offer up the case to the court, but I know you have the citation, so we should be good. Moving on, we get to the Access to Public Records Statute IC 5-14-3-1, Open Door Law, all those kinds of phrases that get thrown around in our practice. And what I would say to you is that, when I took a look at this statute, I was actually surprised to find that the very first section, 5-14-3-1, the first chapter, codifies public policy. And I think that's extremely rare in our practice, when you actually see a statute that, essentially, codifies the public policy. And I'm not gonna read the whole thing, Your Honor, you probably already looked at it, but the first sentence says, a fundamental philosophy of the American constitutional form of representative government is that government is the servant of the people and not their master. It sounds like something Thomas Jefferson wrote, frankly, but more importantly, you get to the last sentence and it says, this chapter shall be liberally construed to implement this policy and place the burden of proof for the non-disclosure of a public record on the public agency that would deny access to the record and not on the person seeking to inspect. It says two important things. 1, liberal construction, which means it pertains to many documents in our judicial system. And 2, most importantly, it places the burden of proof on the state in this case, which Mr. McClelland has already acknowledged, and that burden of proof is, of course, the clear and convincing standard. So I think the point I'm trying to make here is that the legislature felt so strongly about the disclosure of public records that it actually codified the public policy. I just think that's real unique, and one of my counterparts that I practice with would say, that's pretty cool. It's just not the kind of law that we're used to seeing. So moving on, this Rule 5 is kind of the driving force here actually in this access to court records arena that we're in. And the Rule 5 basically says that, exclusion up front is, or I'm sorry, that transparency up front is where the court ought to be with this, and only under extraordinary circumstances should the court deviate from that. And that word, extraordinary, is the second word in Rule 6.2, by the way. And what you see, if you read through these rules, is that there are a lot of terms that are used that just really bolster and beef up that burden of proof, and I think they just speak to how important it is that we have transparency in this community, in this system, I should say, and that's no different in this case. So let's get to Rule 6. Mr. McClellan hit on a couple of the bullet points, one being that the public interest is substantially served by prohibiting access. Again, another strong word. Substantially. Disclosure of the records will create a significant risk. Again, a significant risk of substantial harm to the prosecutor, other persons, or the public. Disclosure will work some prejudicial effect on the ongoing proceedings. So all strong words, again, consistent with a clear and convincing standard. Let's touch on the first one specifically. Will the public interest be substantially served by limiting access? And Mr. Allen's position is no, it will not. It's exactly the opposite. This is a case where the crime occurred over 5 years ago. It's taken almost 6 years for an arrest to be made. Time and public resources have been exhausted over that scope of time. Those are almost impossible to quantify. And any secrecy involved in this investigation, in my opinion and Mr. Allen's opinion, has done not ing, but increased the hype and the public interest. I mean, it's the idea that the public has known very little is what has caused, all this attention to occur. And so, by continuing that pattern or allowing the state to maintain this confidentiality, I think we're just perpetuating the problem. My suggestion is that the opposite would happen if you unseal the records, and that is to say that the public can see the truth regarding the facts that support the allegations in this case. They can see where the expenditure of their tax dollars has gone. And Mr. McClellan talks about the second prong here, and that the release of the records will create a significant risk of substantial harm to the prosecutor, other persons, or the public. At this point, I don't want to sound flippant, but what's the risk? I mean, we've all just walked in here today, with security and the right safeguards in place, and we're fine. There are a few juveniles referenced in the affidavit, and I do understand that may play a little bit larger role in the court's opinion today, just trying to protect those individuals and, frankly, Mr. Allen, the defense doesn't have any problem with redacting some names of witnesses and things of that nature that might serve a purpose, but I haven't heard and nor have I seen in any of these exhibits that were introduced by the state any actual references or appreciable threats that have occurred. In other words, we didn't hear John Doe or, Jane Doe come in here today and tell you that they received a phone call from an anonymous person last week with a threat on their life. I haven't heard an officer say that he or she their lives have been threatened. I think a lot of this is just driven by the social media aspect of this. You can get on Facebook any day of the week and find somebody threatening somebody. Not that I don't take those things seriously, but it's like fast food. Most of that doesn't have a lot of quality to it. It's just quantity. And I haven't heard any evidence today, other than some argument about the law, which actually supports the idea that there are any appreciable threats on anybody involved in this case. And so, any suggestion at this point regarding this second prong, that there will be some significant harm to the public or people involved, I think is just conjecture and speculation. Moving on, here's a practical problem here too, and the practical problem is if the court orders these records to remain confidential, we're gonna be forced to walk into this courtroom and delicately dance through all the factual scenarios in this case because the public's gonna be sitting behind us, and that doesn't seem to make any sense. It seems to make things more difficult. You're gonna have people reading between the lines, All this stuff's gonna go down in print, and then you're gonna have all these, the public trying to decipher what we did and didn't say, and what we're inferring, and, it makes our job way more difficult. I would argue that it's gonna make Mr. McClellan's job more difficult. How do we talk about law and facts in a bond hearing? We've got a bond motion pending. How do we talk about law and facts in a suppression hearing? How do we talk about law and facts in a hearing on change of venue? All those things which are pretty customary in cases like this. The public would be sitting right here the whole time, and so it just doesn't make any sense practically, either. And I'll just finish with this, the burden again. We've talked about the clear and convincing evidence. I haven't gone back and counted. I didn't, do any internet searches before I came in here today, but over the last 5 years, I have some very ingrained memories of state police press conferences in this community. I don't know if there were 2 or 4 or 6 or 8 or 10. I frankly don't know. It seemed like a lot. And in my mind, for the state to come and for the state to be a part of that process of having public press conferences, releasing composites, things of that nature, and asking the public for help, and then to turn around today and suggest to the public, we don't really want you to see what's here. It's kind of like talking out of both sides of your mouth. I mean, that's the way I view it, and I think that's the way Mr. Allen views it, and, we think that the standard is extremely high here, clear and convincing evidence. Nick gave me a little crash course on what the Black's Law Dictionary says. What I know about clear and convincing evidence is, for those of us that practice in civil court from time to time, it's the standard that we employ when we're trying to terminate somebody's parental rights, which I think is pretty darn high. And to say that the state has met that burden in this case, I think is just not accurate. None of these documents that you've seen have any information in them which suggests anything with detail, that somebody's in harm's way or that some other suspect is, out there and needs to be apprehended. It's just conjecture, and we would ask that you unseal the records, if you will, for lack of a better phrase, and let's move on with this. Thank you.
Any response, Mr. McClellan?
No, Your Honor.
Well, gentlemen, I really appreciate your excellent oral advocacy. I will take the petition under advisement to review the exhibits that have been submitted, the case law that's been argued by counsel, and issue a written ruling in due haste. I know that this case has generated a lot of public interest to ND. I know that the attorneys and Mr. Allen deserve this court's attention as quickly as possible. I know with the holiday coming up, that will not interfere with my ability to review my notes and the exhibits and issue a written ruling. Mr. Rossi, you and Mr. Baldwin did file a motion or a petition to let to bail. Can we set that for hearing while we're all here today?
Yes, ma'am.
So that we can get that matter resolved? Are you looking at this year as well, or?
I'm thinking January. Is that?
You're thinking January?
Yeah.
Yeah, that's fine, Judge. I'm out the first week in December, and then we have a jury trial St. Artang here December 12th. So December's kind of...
Okay.
Shot from the state's perspective, Judge, so I'd be looking at January as well.
Okay.
I think my biggest concern is just, frankly, giving Mr. McClellan's office some time for him to get us some of the basic discovery, and us being able to have a little time to sort through it.
I was going to ask you about that.
Yeah.
I know that the prosecutor has indicated it's pretty much an open file discovery policy here in Carroll County.
It is, Judge, yes.
You've received what? Anything?
Well, just the PC affidavit.
Okay. So you don't have any of the formal discovery from the state of Indiana?
Yeah. I don't know what the volume is gonna be like, so I don't want to get ahead of ourselves on the scheduling side. I wouldn't even have a problem, Andy, early February even. Is that reasonable, or am I?
No.
Late January/early February?
I would like some time too.
Are there any particular days of the week that work better? I'm looking at the first week in February then, if that's what you all are talking about. This is my calendar for the next 2 months.
Judge, I will be in a murder trial down in southern Indiana the first week of February, so that would not work for me.
So that won't work for you. Okay. What about the second week? I'm in a murder trial every week, just so you know.
Yeah. Let's see here.
So the second week in February?
I'm more open then. It sounds like TH in the court. Second week of February's fine with me.
Not knowing how long that trial is gonna last, if we're gonna do the second week, I'd prefer, like the 10th? It should be completed by then. I'd hate to continue it.
Okay. I was looking, so you're looking at the first full week? The 10th?
Friday?
You're saying the 10th?
Right.
I don't want to jam you up. I mean, if that's not a good day, we can go to the second, the week beginning February 14th.
I actually would prefer that, 'cause I'd like to come out of that trial and have time to prepare for
Okay.
the hearing. I appreciate it. Of course, I also have another murder trial scheduled that week, but I don't think that's gonna go, so.
What about February 17th th? Will it take all day? Is that fair? Half a day?
I think we should set the day aside.
The day?
Just to be, until we get off and running here, and we have a better idea of kind of how quick the lawyers work and that type of stuff.
Okay.
I'm okay on the 17th, Nick?
That's fine.
Yes.
All right. February 17th. Can we start like at 10? That way, my staff and I don't have to get up that early. My intent is to have as many hearings here in Carroll Circuit as possible. I have no idea what the calendar looks like for the sitting judge.
Sure.
We don't have anything on that date as of now, Judge.
Okay. As of now.
I have the court calendar. Now that obviously is subject to change, but right now there's nothing set for that day.
Okay. So we could set it February 17th th, 2023, at 10 a.m. And I'll make sure that Mr. Allen joins us. I'll get a transport order. All right. I know that we have an Omni hearing in January. There's already been a trial setting, and it was my understanding when I spoke with the judge before, after his recusal, that that trial setting is a first setting.
That's correct, Judge.
Which?
When the prior, sorry to interrupt the court. When the prior judge said it, he did set it as a first setting in March.
Okay.
I'd say we just let it sit for now till we...
Sit?
Yeah. I mean, W. Erie not setting aside the week yet, right? We just have the date on the calendar.
So do we need to change the omnibus date to the let bond date hearing date?
I'm happy to do that if you'd like. Would that be easier for you?
I think that makes sense, but...
I would, yeah. I think it's a good idea.
Okay. So cancel January 13th th and we'll just do February 17th th as a bond hearing and an omnibus hearing. And that's satisfactory to counsel, Mr. Rossi?
Yes, ma'am.
Okay. Is there anything else that we need to do on the record, Mr. McClelland?
I don't believe so, Judge, no.
Nope.
Mr. Rossi?
No.
All right. Thank you, gentlemen.
Thank you.
I appreciate your advocacy.
Thank you, Judge.
Ladies and gentlemen, as I indicated, if you would all remain seated until the parties and Mr. Allen have been removed from the courtroom. This concludes the proceedings had on November 22, 2022, in this cause.